Well, Robert Hunt Financial Market Update Community, it's a special day. We have the gift of hearing from Mr. Nelson Hunt, my brother, an estate attorney in Dallas, all the questions that you and I have wanted to know about what it is an estate planning attorney actually does and how it is that those type of folk can help us. So on this unique RHF Market Update series, this interview series, and this is our first, so don't worry, you haven't missed any. Mr. Nelson Hunt, undergrad, University of Virginia, law school, SMU Dedman School of Law. He got his LLM in taxation from New York University School of Law. He practices at his firm, Nelson H. Hunt PLLC. He's board certified with the Texas Board of Legal Specialization, Estate Planning, and Probate Law. And he does a lot of stuff. So I'd send you to his website, nelsonhunt.com, if you want to learn more or find ways to engage him in his services. But without further ado, here we go. Okay, so it is a delight and a pleasure here at the Robert Hunt Financial Market Update. We've got our interview today. And guys, we could have brought in anyone. And you know that, and I know that. The podcast is at such a level that the phone gets picked up. But we have a very special guest, per the intro I just recorded, Mr. Nelson Hunt, estate attorney extraordinaire. As many of you know, Nelson is a fan of the show himself and also a believer in keeping his costs low, his investing simple, and his time horizon long. So for those of you in the studio, please keep your applause at a minimum here as we try to answer questions. Let us give a warm Robert Hunt Financial welcome to Nelson Hunt. Okay, keep it down back there. Keep it down.
Thank you.
Yes, it's a light to have you here. So guys, I just want to say, having an estate attorney like Nelson, who's my brother, has been such a blessing to the practice. I can just text him and ask him questions. But occasionally, I thought, you know what we need? We need dedicated time with Nelson. We need the brain, the mind in the studio so I can ask all those questions I want to ask about estate planning, wills, etc. So Nelson, as a client comes into the Robert Hunt Financial world, one of my checklist items on every client has a checklist. They got like a 15-point checklist. One of those checklists, like a car, is do you have an estate plan? So what I want to know, I'm always trying to keep my costs low. So you know that's my modus operandi. That's my default position. You know who my father is. So that's always that's pretty well genetically ingrained. But what happens? Why do we need an estate plan? Like okay, so let's say I just get married or I'm just a single person. Why do I need any plan at all? Why can't I just, as they say, just go cold turkey? Don't need anything. Why do I need to meet with someone like you?
Yeah, so the primary reason that brings people in usually is when they have a child, they'll want a guardian of their children named in some document. And so married couples usually uncomfortable with the concept that that's undecided. And if they were to die, it would be up to a judge to appoint a guardian of a minor child. So oftentimes being able to name that person is what brings clients in, and that's done in a will. Another issue that brings people in is just wanting certainty about where their property goes at their death. Now, there are what are called intestacy rules in Texas that say this is where your property goes if you don't have a will, but clients oftentimes like to have the certainty, and that's what a will provides, as to where their property is going to go if something were to happen.
Okay, so you said something about intestines. Okay, so hold on. You said intestacy. Hold up. So you're saying if I don't have a will, there's something called intestacy, rhymes with intestines, not intestines. Intestacy rules that the state of Texas provides?
That's right, yeah.
Okay, so, what is that? Okay, so I'm Mr. Frugal. I just don't even want to, let's say I just go cold here. What's happening? What occurs there?
Yeah, so those rules partition or divide everything you own as a married person into community and separate property, and they say this is where your separate property goes and this is where your community property goes. And generally speaking, all your community property is going to go to your spouse under those intestacy rules, but there are some differences when it comes to separate property as to what would happen to that property, again, if you died without a will.
Okay, and it's okay, separate versus community, right? Okay.
Yeah.
$5 words here, class. So help us. What would just community property be like? What is community property versus separate property?
Yeah. So in Texas and in a handful of other states, there's what's called a community property system. And that means that the presumption for a married couple is that everything that the husband owns and everything that the wife owns, no matter how it's titled, is considered community property unless it can be demonstrated otherwise. And there are only a couple instances where property could be demonstrated to not be community, to be separate. That's property that you own at the time you get married.
Okay.
Property that you inherit during the marriage.
Okay.
Either by gift or by bequest.
Okay.
Or property that becomes your separate property through either a premarital agreement or a postmarital agreement.
Okay, so just bouncing ideas here. If I have a Chiefs jersey signed by Mark Vanover and other greats of yesteryear, and I brought that into the marriage with me, is that separate?
That is separate.
Okay, so memorabilia swag. Now, what if benevolent man that I am, I wanted to ensure that was not separate? Is that something that would be something? Hey, you would sit down, husband and wife, and I say, hey, I want to make sure Molly gets this signed jersey of all the 1990s Chiefs greats. I would have to stipulate that because otherwise it would just default to. Am I thinking about that right?
Well, when it comes to your at death, your testamentary estate plan, even your separate property is probably going to go to your spouse.
Great. Okay.
As long as you have a will, and there's some nuance to that.
Yeah.
But one thing that brings to mind is that it's fairly common for married couples who have some items of separate property to do what's called a conversion agreement, where they both sign it, and it would say in your case, this Chiefs jersey that was my separate property is now yours and Molly's community property, considered owned one half by each of you.
Okay.
And there are some tax reasons why that may be beneficial for couples, and so that's part of the conversation whenever they engage in estate planning.
Interesting. Okay, that does help. Okay, so oftentimes, what I've heard is great. There's this intestate business, the state of Texas. Just this worst case. If we go worst case, we just do nothing. The scary part, what I'm hearing from you, is it really is who's going to take care of the kids. Like that's what brings in a lot of couples. Because if you're saying if husband and wife pass simultaneously in a train accident, and it's not, let's say it's not clear, what does happen in those situations? So again, let's say we were not wise, we did not have an estate plan, we had children, heaven forbid, parents pass away. So what's the process? What happens?
Yeah, so I don't handle those matters, so I don't have personal experience. But generally speaking, a judge will make a determination as to who should be the guardian of the minor children.
And people will put themselves forward, perhaps like a grandparent would compete in a way. Okay.
That's right. And so you'd prefer to have something in writing from the parent saying this is who we would designate. And now to jump off of that point a little bit, another downside, a big downside of dying without a will is not just the uncertainty as to guardians of your minor children, but it would mean that your probate looks much different if you die without a will. And in particular, you have to go through what's called an heirship determination. And that involves essentially getting a third party to go investigate your family history, and in particular, investigate whether you had any children outside the marriage and things like that, and reach a conclusion and present it to the judge saying this is his family. If you do a will, your will says this is my spouse, these are my children, and so and then your will is admitted to probate. You avoid that whole heirship determination process. It's costly, it's time intensive. Probating a will is much
and spell
cleaner.
the word heirship for our listeners.
Yeah, HEIR.
Okay, did you hear that? It took me a little while to catch that. I'm thinking we got a blimp coming in here.
No.
It's the airship.
It's the air-
And because you jump on the airship, no, this is air. H-E.
Yes.
Okay, great. And then define probate. That's the word you've been using. Just what is that?
Yeah, so probate probate's the name of a court. They're called statutory probate courts in Dallas, and other cities have statutory probate courts. So it refers to a court. And then the process really refers to the act of, after someone dies, filing their will with the court and then having a hearing where the judge says, this is a valid will, and I hereby, number one, admit it to probate. I say it's valid. I say it's going to be admitted to probate.
Okay.
And then number two, typically, the judge appoints the executor and gives that person what are called letters testamentary.
Okay.
And that those letters testamentary give the executor the legal authority to act with respect to the decedent's property, to go to the bank and say, this bank account was in the name of the decedent. I want to transfer the money, or I want to retitle the account in the name of the estate.
And even if, and forgive me, even if like a husband and a wife, let's say the husband passes, it's going through probate.
Typically, yes. Yeah. So if
and it may not be that the wife is the person who's actually running that process.
Not necessarily, but
sometimes,
almost always.
Okay.
Spouses will name each other as their primary executor.
And they will do that in consultation with someone like you, an estate attorney. That's part of the game plan. Is
right.
Okay, so you'll go through that, and then how is that process? Because I know sometimes in your work, don't people just like hire someone like you just to be that person to help guide the probate?
An executor will hire a lawyer. So I
in all instances.
Yes,
you can't just run and gun this thing.
Required.
It's required.
You cannot represent yourself, so-called be pro se before the court.
Lawyers union loves that.
That's
deal.
right.
Keep the bills going, boys.
You're required to hire a lawyer.
I see.
And so naming your spouse as executor is not necessarily setting them up to have to navigate that on their own. Your spouse is going to hire an attorney that will handle all these probate court filings and really hold their hand through that process.
And then what? Okay, so this comes up all the time. You know, all these Vanguards, Fidelities, banks, all these folks are always telling us like, okay, like named account stuff, like, you know, beneficiary information. What advice do you give people on? Okay, great. If I've got my will, let's say they went to Nelson Hunt or someone 80% as good as you, and elected to kind of say, hey, look, I'm going to, you know, this is the plan. The will's tight. Everything's good. Do they need to mess with that sort of beneficiary information on those accounts? Or like, how do you think about that?
Yeah, so most people already name their spouse as their primary beneficiary on their retirement accounts and life insurance policies. And I won't recommend that they do anything different except in extraordinary cases. I'll usually say...
What about brokerage? You didn't say brokerage accounts there.
So brokerage accounts is different, and you want to avoid payable on death designations or survivorship designations, generally speaking, with your brokerage
Why?
accounts.
Let's talk about that.
Yeah, so the general reason is payable on death and survivorship accounts trump what's in your will.
Okay.
And so even if your will says, I leave it all to person A, if you own a survivorship account or a payable on death account that leaves it to person B, that designation is going to win out. And person A is
let's just, for folks in the back, did y'all hear that? okay, that's a big deal. So what I'm hearing you say, Nelson, is even if you get a top-notch lawyer like you roll through the will, it's locked and loaded, I's dotted, T's crossed, but you err on in your Vanguard Fidelity account and you put on those deals that your beneficiaries are X, Y, and Z, and that's different than the will. You're telling me the Fidelity and Vanguard information trump the will.
Exactly.
Wow. So and I'm sure that happens with folks. I'm sure it's not good. But what I hear you saying though is, why were you so kind of lenient on these IRA deals, and why were you so tough love with us on these brokerage accounts? Why the distinction?
Yeah. So in both cases, you have to be careful. But the sensitivity on the IRAs is that they are treated differently for tax purposes. So there is some significance to how you leave them. And in particular, I'll do estate plans where the documents may call for property to go into a trust for a spouse. But oftentimes, I'll still recommend that their IRAs name their spouse outright and not in trust. And generally speaking, naming a spouse outright as a beneficiary of an IRA or a 401k is more income tax efficient than putting those assets into a trust.
Interesting. Yeah. So you've got your tax hat on as well as an estate planner. You're thinking about different buckets here that you can help people with. Okay, that is helpful, and I want to just bring the listeners into a little experiment we ran years ago and just get your thoughts on it today. This is something people ask me all the time. So here at the Robert Hunt Financial, not only market update, but the IRA practice, we serve a wide range of folks. Some of these folks are coming in and some of them are just out of college, kind of ready to go. Other folks are high net worth to very high net worth, and therefore, expending resource on someone like you is really not even a blip on the radar. Walk us through that experiment we ran where we were seeking to use, LegalZoom.com or just some of these lower cost alternatives, and like What are your thoughts on those today? How did our experiment go? And what are your thoughts today for the more I say cost conscious consumer, because it may not be that everybody can spend, and I don't know if you want to be on record for what you charge. It's a fine value, but if they don't want to do the sit down and the couple grand here, and they want to do the 180 LegalZoom, walk us through how you would advise someone like that, just as more as a brother than as a estate plan. Let's say kind of just. You're just looking at someone here. How do you help them?
Yeah, so our experience coming out of that experiment was when a client does a LegalZoom or uses some other program to do their will, oftentimes the will looks good, but it's not signed correctly. And it seems like a simple thing.
Tell us what that means. What does it mean to be signed correctly? Because in my mind, you just write a signature. How could you mess up a signing?
Right. So in Texas, for a will that's printed, not handwritten, but printed, typed out, to be valid, it has to be signed by the testator, the person making the will, and also signed by 2 witnesses.
Okay.
Then on top of that, almost always when you're doing a will, especially doing a will with an attorney, you'll have included what's called a self-proving affidavit at the back of the will.
Okay.
And that is also signed by 2 witnesses and by a notary, and also, by the testator again.
So this smells like German engineering. I'm already hearing like 4 different things that could go wrong here. So I see. Okay.
And so because there are multiple places to sign, and also because of just the practical headache of rounding up witnesses, and typically you do not want your family members to be witnesses of your will.
Okay.
It's hard for clients who are doing it on their own to get it across the finish line.
Yeah, that makes sense. And it also, I mean, I'm from that same experiment. I mean, while there are cost savings, that was, we actually tried, I think, 3 different platforms. And it wasn't just LegalZoom, and this is not a diamond on LegalZoom. What Nelson's saying is it's a little more than just dotting the I and crossing the T. There's this kind of emotional, can you push through? And I've heard you say this, Nelson, sometimes, and it's hard for me. I've got down on my list, when I've got a little checklist, need to get the will done, and sometimes it stays on there for like 3 years. Because denial of death, we all have it in a sense. It's death is something that happens to someone else, but it's so critical that we plan on this. So this comes up in questioning, Nelson, and it's usually the case that folks believe, and this is where you can set the record straight here, Nelson Hunt. Folks believe there's a little bit of a Wizard of Oz here, and behind the curtain in estate planning, there are kind of alchemists that can turn metal into gold in estate planning. Meaning, and it's always kind of this, the reason I say Wizard of Oz, it's always a man behind a curtain in a sense, and smoke and mirrors, and it's all confusing. But sometimes I'll sit with clients who are high net worth, and they kind of say, hey, I want to kind of do the secret sauce. How do you coach folks in those situations? Someone who may be above this estate taxes, if I could be so bold in the presence of a state attorney, there are limits the government has for us per person on what can pass through your estate without taxation. So oftentimes people will employ someone like Nelson as a means of avoiding that. Nelson, could you just walk us through, how do you even counsel folks in that manner? And is this Wizard of Oz thing true? Are there really levers that the wealthy have that perhaps they can pull and push on that the rest of us on LegalZoom.com can't do? Like what's going on behind the curtain? What are you guys doing over there?
Well, I will say it's partly true that there are techniques that are expensive because they require time and effort on the part of attorneys.
Ballpark it. Hit me with numbers. You say expensive. No one knows what that means. 10 grand, 5 grand, 30 grand?
Yeah, in the range of 10 to 15,000,
okay,
$20,000.
So kind of a 15-year-old, 10-year-old Camry, 8-year-old Camry.
Right. And typically where you get fees in that range is because you have complicated planning. You have multiple documents that need to be drafted. You have memos that need to be prepared, describing the strategy. And oftentimes there's a lot of maintenance that goes along with structures that are created, whether it's trusts or partnerships. Oftentimes there's loans involved. So kind of the part behind the curtain, there is a lot going on, but it's also not a free lunch. You're always paying with complexity. And so that's just one thing that every client has to take into account. And in my practice, I have to get comfortable that the client has the appetite for complexity to kind of venture into those waters. All that said, there's some straightforward planning that is less kind of behind the curtain, so to speak, and typically that will revolve around using your $17,000 per year gift tax exclusion. That's a real simple way to move property downstream, so to speak, from parents to children. There are ways to do that without an attorney. In terms of
That's
funding.
always nice, kind of sidestep the attorney. Thank you for
Right.
saying something about it.
And there are different vehicles. You can use that to fund 529 accounts, educational savings accounts. You can use that $17,000 exclusion to fund Uniform Transfers to Minors Act account, so-called custodial accounts. Then you can go to a lawyer and create what are called crummy trusts, named after a court case that demonstrated this technique, where you create a trust, give the $17,000 exclusion to it, and give the child a withdrawal right. Those are some of the simpler ways to move assets downstream. But when you start talking about making larger gifts that typically require filing a gift tax return, that's where a little bit more complexity comes in. And then especially when you start talking about techniques that are designed to move property at no gift tax cost, whether that's sales or grantor retained annuity trusts, those bring in a kind of a new level of sophistication that requires legal help, legal fees.
I'm glad you brought up that sophistication, Nelson. Something that I've run into a couple times that has always perplexed me, and I'm curious what your thoughts are on it, is oftentimes I will meet someone, usually for the first time, and I'll be trying to get my arms around their investing. So kind of where is the money and how's it invested? I call it autopsy without blame, because we want to create a safe environment for anyone can kind of tell me what they're doing. And oftentimes what happens, particularly with older clients who've accrued a deal of wealth for themselves, is the clients will be, in many ways, as I see it, chained to the complexity of an estate plan so much that they can't even tell me what monies they're allowed to get, when they're allowed to get it, because of the various, not your practice, of course, but I could imagine it would happen that the client says what they want, you execute on it, and all of a sudden 10 years later, they really don't know how it works or what, and they can't describe it to me, and all of a sudden I'm on the phone with an estate planning person, and they, it just seems like a mess. And usually, as I see it, Nelson, it's usually, it feels politically motivated. Sometimes maybe the Democrats are getting in, they're going to hammer down on this exemption amount in a big way, so you better get your ducks in order yesterday, and all of a sudden you have all this complexity, and I look up and I sometimes think, gosh, was the juice worth the squeeze? Well, hindsight's 20/20. How do you address, you mentioned complexity, how do you address that complexity? I see it from an investor advisor's perspective, where I just don't like it. I hate all of it. There's not a single ounce of the complexity that I think is appealing. I see deer in headlights with clients. It bothers me when people don't know what money they can use. And then it bothers me that I myself can look at the flow chart some estate planning person put together and think, ugh, what in the world? How do you address that yourself with your practice, with your people? What advice would you give in a situation like that to someone?
Yeah, so one way that I address that would be to emphasize the client doing their testamentary, their at-death estate plan first, before they engage in any so-called inter vivos or lifetime planning. And I think usually the lifetime planning leads to the type of complexity that you're talking about.
Yes, that's exactly what's happening. Yes.
So you can do a testamentary plan that takes full advantage of the available gift or really estate and GST tax exemption amounts available.
That's Generation Skipping Trust. He's using acronyms. Generation Skipping Trust is what that GST was. Thank you.
And so you can get clients across that finish line, so they have their testamentary plan, and that doesn't involve any during life complexity. They may, as part of that plan, have a revocable trust.
Okay.
And maybe they'll put assets into that, but maybe not. But even if they put assets into that revocable trust, they can take it out themselves. There's really no rules.
This is great. So just mechanically, I'll say this. So let's say someone does this, great. They don't have to do all the complexities in life, meaning we're not throwing things into different shells, and correct me here when I say something wrong, and I'm not trying to... It's just when they die... That's when it kicks in, and that's when the money flows to these various vehicles?
Yeah, and so that's when there's some more complexity that's introduced, and So yes,
But at the base level, what I hear you saying, what I think should be an encouragement to people, where you, if you, sometimes people don't know what to order from the restaurant. So even before they go to an estate planner, I feel like there's an intimidation factor on, well, I don't even know what to say. But what I hear you saying is the estate planning kitchen can cook up something that says, hey, look, we don't have to jack with any of your existing investing structures as they exist today, correct?
Yes.
We can actually put something in place that it actually is, once you pass, that's when maybe some of that German engineering kicks on. But in the interim, in this present state, you really don't have to do all these peculiar things that will make you ask the questions that I receive sometimes, which is, I don't even know what money I'm allowed to spend. Is that fair? Someone can come to you and kind of ask, hey man, just keep it simple in the lifetime, and then do the fancy footwork at death.
Yeah, that's right. And every client has a different appetite for complexity, but that's certainly an option on the table for even the wealthy client whose combined estate is well in excess of the $26 million exclusion. They can keep it simple during life and keep their financial life simpler.
Well, that's great. I mean, I feel like it almost takes, and you're cut from a similar cloth. Here at the Robert Hunt Financial Market Update, we keep our costs low, we keep our time horizon long, we keep our investing simple. If Nelson Hunt were to have a Nelson Hunt Legal podcast, would you be keeping your estate planning simple?
I think so.
Okay, we've got him on an I think so, which is, that's a lot for a lawyer. For those of you listening in the back, okay, that's a big deal. If a lawyer says he thinks so, that's almost a yes with an exclamation point. Because I feel like that, and I know that's the true of you before I ask that, but I feel like that to me is oftentimes kind of this, sheep to the slaughter moment when people do go into any lawyer's office and they don't exactly have a clarity on what outcome they want. And of course, like any great helper a lawyer would be, they might say, oh, we can cook up all sorts of beautiful things that are perfectly legal and optimize, oh, by the way, for tax efficiency. But they're not thinking about this human element, this management element, this investing element. They're not looking at it full circle. And so that's why I like trying to get people on the same page, whether it's me or you or me, another estate planner, or you and some subpar financial advisor. You're always wanting to put people on the same page. And that's why I would encourage anyone listening, I would be suspicious of any time siloing these things. Like anytime an estate planner is saying, I would want the financial advisor part and parcel knowing what's going on. I think, Nelson, you would agree with that.
Yeah, I would agree with that. And I just want to say that my I think, and maybe my hesitation on endorsing wholeheartedly avoidance of complexity, there is, of course, well, not of course, but we just haven't really gotten into this topic. There is an estate tax exemption amount that's currently $12.92 million per person. Mm-hmm. And under current law, that amount does decrease to around $6.5 or $7 million on December 31st of 2025. And for certain clients, it's, and generally speaking, to add to that, if you can make taxable gifts before that date, and then that law stays on the books and the exemption amount is allowed to sunset, you are able to move more assets into trust vehicles or other vehicles outside of your estate than you will be after December 31st, 2015. There was a similar cliff, so to speak, in 2012. There was a lot of estate planning done around 2012 for that reason, to move assets out of a client's estate or into a trust vehicle, so that if the client then later passed away, the client's estate would have gotten the benefit of that pre-December 31st higher exemption amount. So that is something that, especially as we get closer to the end of 2025, that will be a frequent topic of conversation, not only among estate planners, but financial advisors and estate planners, myself included, will make a sincere push probably to recommend that very high net worth clients at least consider moving assets into trust or doing other types of planning that will allow them to take advantage of that higher exemption amount before it sunsets.
Well said and super helpful. And that is exactly what gets on people's minds and gets them going. And then this is a point of history, Nelson. I think you taught me this or someone else. Trivia question. No one in the audience answer this. When was the last time the estate tax exemption amount was reduced?
Yeah, so there was a blip in 2010 when
for a year.
the estate tax went away for 1 year. But other than that, my understanding is that generally the exemption amount has gone up every year consistently. I think for
Since
6 or 7 decades.
Since
at least.
George Washington crossed the Delaware? Or,
Well,
okay,
since the estate tax was enacted
Okay.
over 100 years ago.
Okay, and that is always interesting. I think both things need to, it could be in this 2025. This is the cliff, and therefore what Nelson is saying, very wise. Kind of if you need to do something, it kind of does make sense. It creates a little bit of a sense of urgency to do something. Maybe you should have done otherwise, but at least maybe creates this. Even if the Democrats or Republicans like this as a football to perpetually punt back and forth for their various constituencies, it at least could create a sense of urgency that people could do good planning otherwise. And oh, by the way, yes, it helps that 2025 is coming. With this interview, I tell you, we've covered a lot here. We've covered a lot of good things. I always like to ask, though, before we close, I've got a couple questions, so maybe don't turn off. Keep your radios dialed in. One is, what are mistakes that you see people make when they come to you that you try to coach them out of? What are things that you're kind of common occurrences that you say, man, I wish I could have maybe twisted their arm to do this more. I wish people came in with a better understanding of this. What can the Robert Hunt Financial community maybe not make a mistake that you see in your work?
Yeah, so that's a great question. One that comes to mind is for one of the two spouses to be engaged and the other not. And so in my experience, I do a lot of planning where I represent both spouses, and that's typically the more efficient way to do it. And in my experience, when I have only one spouse contact me and say that spouse says, I just want to meet with you, and I can just tell my spouse later what we talked about, the planning almost never goes anywhere. And so that's mistake number one is not getting your spouse on board initially for that initial meeting. Another might be just getting too caught up in, as you're suggesting, complex planning. And so I have some kind of projects that seem to go on longer than they should, because a client is maybe enamored with a complex structure, and I'm happy to help the client and assist them and counsel them in that direction. But if I would, this isn't really a legal judgment, but my perception is that sometimes that sentiment is kind of based on this peer pressure idea of, hey, my partners in my firm all talk about doing a family limited partnership, or they all talk about creating this certain type of trust structure. And so I feel like I need to do that. And sometimes that leads to some wheel spinning. So point number two might just be make sure that you're thinking for yourself and with the advice of financial advisors and estate planning attorneys, make sure you're thinking for yourself about what works for you in terms of planning. So, and those would really be my two big takeaways. Get your spouse involved, and then do what works for you, not what somebody else might be telling you should do.
Well said, and I think that's a great corollary to investing as well. I mean, both of those things, I can certainly attest that getting a spouse involved, and then don't do what your friends tell you to do with investing, right? Isn't that what we preach here at the Robert Hunt Financial Market Update? Well, at the Nelson Hunt Legal Update, he's telling you the same thing. He's telling you, hey, like, don't just look to the left and the right and decide, hey, this looks complicated and this sounds cool. And oh, by the way, what fun water cooler talk is it to say, I did some whoopsie-doopsie lipo trust XYZ. It sounds cool until you got to, on the back end, figure it out. So very, very wise words. Well, Nelson, I want us to close with this question. On a scale of 1 to 10, how much do you like index funds?
11.
Oh, man, that's what we like to hear. Well, Nelson, on behalf of the whole Robert Hunt Financial community, we appreciate your time, appreciate you coming in. And I will say Nelson is certainly a frequent referral here for the Robert Hunt Financial Market Update. And I would encourage you, this has been the case previously, but a complimentary call is not out of order. So if someone desires a 10 or 15-minute look at Nelson Hunt and your process, they can do, is there a deal like that where you can help them?
Yeah, and that's something I should mention. So, I take quick calls all the time from financial advisors or potential clients, and a lot of that, some of that by phone, some by email. But just to give you a cadence of my process, and this is probably typical of most estate planning lawyers, usually it'll start with an hour and a half meeting, and the goal and if you're married, with both you and your spouse, and the goal of that meeting is to talk about everything we would need to discuss for me to prepare your what are called testamentary estate planning documents. That includes not only your will, but also a slate of disability documents, powers of attorney that everyone typically does when they do an estate plan. And I'd quote you a fee at the end of that meeting, sign you up as a client, and then my office would draft the documents, and you'd come back once more for a signing. Almost all will signings are in person at an attorney's office, typically because of the issue we mentioned before, which is it's a little bit tricky to get every document signed properly. And so I guide you through that signing process, and then you end up with all your hard copies of your documents and electronic copies. So your time spent has really just been 2 meetings, the hour and a half intake, and then it might take 30 minutes for the signing at the end. And you walk out with a summary of everything, and then also the documents themselves. And that's pretty typical of lawyers that are in my area. And the whole process, depending on how busy I am or how busy you are, I try to get my plans done within a month, but sometimes it can drag on to 2 or 3 months, but that's about a guess as to the total time frame.
Perfect. Fantastic. And then you also, you do other things as well from a legal perspective. So I'd also encourage our listeners, it can oftentimes be nice to work with someone with the heart of a teacher. Nelson has the heart of a teacher. So if you do call, he may tell you, hey, I can't do that, but why don't you go here? Or, yeah, I can put together that partnership doc for you. Or, yeah, I can do that. He's done some legal work for the Robert Hunt Financial megalopolis. So I think oftentimes, Nelson, it can just be, hey, just ask the question. Don't be afraid. Just because you're going into an attorney's office that says they do X, Y, and Z, if they've got the heart of a teacher, as Nelson does, don't be afraid to just simply say, hey, look, high trust situation here. This is a high trust person. Just ask them, hey, what do you think about this? If you're in your business and you don't know, Nelson can find you someone who can help, or he can at least give you guidance on how to keep your legal structure simple as possible as it may be. So thank you, Nelson, for coming in and making the time for us, and we wish you the best in all of your future endeavors.
Thank you so much, Robert.